everyone. As we are aware that everything is changing around us due to the evolving technology, be it shopping, booking tickets, ordering food, we are all doing it by online means. And when we are entering into such online mediums, what are the legal implications of it? To discuss the same, we have with us Mrs. Sushila Varma, who is an advocate and chief consultant at the Indian. Welcome, ma'am.
Thank you, Ashita. Ashita, are you aware that people are getting married online?
No, I wasn't.
No, they are. There are many times people have, in fact, it's not a recent event, it's been there for a few years now. Many people are doing their marriage online, and this actually evolved in a big way during the COVID times.
Please shed some light on what are digital contracts.
Putting it very simply, digital contracts are all those contracts that happen online. As the term says, digital contract, it means it has to be something that's done over the internet. Now, what happens is parties don't meet in a virtual media, right? They are just there using, like for instance, in a website. It's an interface. We're using the interface, but we are not interacting with anybody. So there is no offer and acceptance the way we do it in the physical world. So what happens is when we go onto any website, invariably there are terms of use, and there is also a small tick box which is there in which it says I agree. The minute you click on that I agree, it means you have accepted the legal terms and conditions that have been put by the website management.
Better understanding of our viewers, can you please tell us if there are any types of their digital contracts?
Yes. To my mind, there are, I think, 5 types of digital contracts as we talk. The first is what is known as a unilateral e-contract. Now, a unilateral e-contract is one in which there is only one party, that is the party that has started the website or that is running the website. It says that the minute you enter into their website, it is deemed that you have accepted all their terms and conditions, and a contract is signed and it is binding. So that is, I would say, in cases like suppose a newspaper is offering some rewards. Okay, it's a reward-based program, and you enter into that particular platform or that particular website, and you start entering your details. It means that unilaterally, the person who has made the reward-based offer has set conditions, and you, by putting your details, have accepted those particular conditions, and as such, you have bound yourself by a unilateral contract. Now, such contracts do not have any, there's no bargaining power, there is no basis for which you can reject or accept any particular terms. They say we are offering a reward, you go into their website and you say, yes, I want to be a contestant. It means no matter what their terms are, you have to accept it. Now, the second type of contract is what is known as a click wrap. Now, in a click wrap e-contract, there is a button in which you say, I agree. The minute you click on that tick mark or you click on that box, it means that you have agreed to be bound by a click wrap agreement. Mostly this is done in software licensing agreements. Then there is a third type of category which is known as browser app agreements. Now, under these electronic contracts, consumers accept the terms and conditions by merely visiting the website. That's why they're known as browser app agreements, because you go as a browser, the minute you browse, it is deemed that you have agreed to the terms. Then there is another type of agreement which is known as a shrink wrap agreement. Again, this particular e-contract is very prevalent in the software industry. What happens is the minute you open the software packaging, it is deemed that you, by opening the shrink wrap, you have accepted the terms and conditions, And as such, whatever are the terms and conditions that have been set in the software, it might be inside the box, it might be somewhere written on the box, it is deemed that you have accepted and you are bound by such terms. And finally, I would say there are these smart contracts that you have today in blockchain or in cryptocurrency, which are also known as smart contracts. Now, these contracts also are contracts that happen automatically. You go to a crypto website, you go to any website using blockchain technology. The minute you have entered these particular websites, it is deemed that you have accepted the terms and conditions and you are bound by these terms and conditions.
Ma'am, are there any legal aspects of digital contracts?
Yes. Contracts in India, whether it's digital or whether it's in the physical world, will always be guided by the sections that are mentioned in the Indian Contract Act 1872. That means these contracts, if they meet the requirements of the contract law, that is, there is an offer, there is an acceptance, there is no undue pressure when you are signing the agreement, there's a consideration. If all these terms are met, it is deemed to be a legally binding contract, a valid contract, and it would be enforceable in a court of law.
As you have mentioned that Indian Contract Act is one legal aspect of for digital contracts. So are there any other laws which govern it?
Yes, certainly. I would say the most important law after the Indian Contract Act would be the Information Technology Act, better known as the IT Act. Now, with the IT Act, you have several rules. So, all those rules will be applicable when you are using a website or when you are interacting on any particular website or any particular digital platform. Then you have the digital signature rules, which is again applicable because many a times we digitally sign documents, so you're bound. Then, of course, I think these would be the main laws. But over and above that, you would also have the Consumer Protection Act because many a times when we are buying goods, we are buying them as consumers. So, a consumer can be somebody who buys goods physically and at the same time also somebody who buys them virtually. Now, again, I would say that even the Companies Act may be applicable because now a lot of electronic filing is started and a lot of things are done by companies online. So that was another law that might be applicable. And I would say that in the electronic or in the digital world, the Indian Evidence Act is, of course, extremely important, which now has been replaced by DSA. But what happens is when you use any electronic mode and you want to get a particular electronic record admitted by court, there is a certain format or a format that has to be followed or a certain affidavit has to be given in which you inform the court that the evidence that you are using is reliable evidence, not being tampered, not a result of software corruption. And based on that, the court will accept your evidence and use it at the appropriate time. Continue.
Is there any case law pertaining to digital contract?
Yes. Generally, what happens when we enter into contracts, there is an offer from one side, an acceptance from the other side. Both parties sign the contract. But these days, it's not as if it happens on the way it used to happen in the older days. Now, in a very interesting case in the Supreme Court of India, Trimax International versus Vedanta Aluminium Limited 2010, This was the first time that the Supreme Court of India had ruled that the terms of a contract can be discussed or formalized or finalized by virtue of an exchange of emails. So, this was the first important judgment that the Supreme Court passed, in which the Supreme Court held that even when you are discussing the terms over an email, it would be deemed to be a valid and enforceable contract if you're able to show that you have met all the other conditions of a valid contract. So, in this particular case, the contract was not even signed by the parties, neither was it registered, yet the Supreme Court upheld the legitimacy of electronic contracts. And I would say this is the first in a line of several contracts that have been upheld by various courts in India.
So, ma'am, as we are aware that when we enter into any contract, be it physical or digital, there are clauses and terms, and such clauses can also be unfair. Is there any case law for our understanding through which you can explain the unfair terms of digital contracts?
Yes, there is a very important case pertaining to Uber technologies where an Uber cab driver in Canada had taken the company to court. Now, what happened is, in this particular matter, in 2022, the Supreme Court of Canada ruled that all terms which you enter into when you are digitally entering into a contract are not binding. Now, let me explain what happened in this case. The person Heller was a driver and he was driving for Uber Technologies. When some dispute arose between Uber and Heller, he raised his objections, and Uber said, if you have any problems, go to Netherlands, because the clause or the terms that are there for your not employment, but for your acting as a driver, mention that you have to go for arbitration to Netherlands. Now, why would a driver who's driving in Canada be agreeable to go to Netherlands for an arbitration?
And was it the dispute clause of the contract?
Yes, it was, because it said if you have any dispute, all disputes have to be resolved by arbitration, and that too in Netherlands. Now, Netherlands would suit Uber, but it definitely didn't suit this particular driver. So obviously, he challenged that particular clause and he went up to the Supreme Court of Canada, and the Supreme Court felt that any clause that is unconscionable and cannot be deemed to be enforceable. So the Supreme Court said no. He had unequal bargaining power. He didn't know that he had to go to Netherlands to resolve any dispute with Uber. So since he had unequal bargaining power, how can you expect that he will be bound by this clause? And they set aside the clause. So taking this as a cue, I would say even in India, if you have entered into a digital contract, it does not mean that if the clause is very unconscionable, you are bound to accept it. You can challenge it, and based on the Uber judgment, I'm quite sure that our courts would also not accept that any person who has signed a digital contract which has unfair clauses is bound by it. Now, having said that, I think, Ashita, we can close our Q&A. So, do you have anything to say?
Thank you, ma'am. That was very insightful, and I hope our viewers must have liked it. Thank you.
So, if you have liked this video, I would request you to please like, share, and subscribe. If you want to be notified of our new episode, which comes out week after week, please press the bell icon and you will be notified. A small word of thanks to my team that goes out of its way to prepare all these topics. But for them, I would not have been able to do this particular program. And I would request all my viewers to please share these videos so that they can have a larger outreach and more people can benefit by the legal tips that we are trying to spread across the country. With this, I'll say namaste. Thank you and see you at the next episode.